June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This court hearing gets wild real fast. Judge Urich doesn't hold back as she deals with a sovereign citizen who's either faking crazy or genuinely lost it. The guy's facing 2 counts of public indecency after getting caught causing a scene in a park. What do you think? Is he just acting, or is he actually off his rocker? Drop your thoughts in the comments. If you're into content like this, don't forget to like and subscribe. Let's dive in.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Marklewood Woods, which looks like it was deferred as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000. Cash or surety, no 10% allowed at this time.
I've got to say, Judge Urich is really good at what he does. I've seen other judges get frustrated or waste so much time dealing with sovereign citizen types, but Judge Urich shuts down that nonsense super quickly. And honestly, the way he calls out their contradictions, low-key hilarious. He's got this subtle way of putting them in their place without making a big scene. Also, that $50,000 bond? Definitely a solid call. This guy already has multiple felony charges, and he's still young. He does not need to be back on the streets anytime soon. Hopefully, he can turn his life around. But here's the thing, this guy actually seems mentally ill, and I honestly can't tell if he's faking it or not. What do you guys think? Alright, let's get back into it.
Mr. Stringer wishes to bring various motions before the examining judge. And that could include a motion to modify his bond. That is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with the, what is going on? Right?
I'm sorry, sir?
I'm being charged. I'm being charged with entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
I don't know if you guys caught that, but he literally just said, "We're about to go to war." Honestly, that might be one of the dumbest things I've ever heard someone say to a judge. If I were the judge, I'd have slammed him with contempt right then and there. Now, we're about to jump into his second hearing, this time with a different judge who does not hold back. This one gets super heated. Let me know what you thought about the first hearing, and let's dive into the second.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Derek Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
Living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mott-Lewis, can you prepare an order for competency review?
Do you guys think this competency review judge is making the right call by placing the defendant under a competency evaluation? Here's the deal. When a defendant wants to fire their defense attorney, it can cause big problems for the court if they are mentally incompetent. Without a lawyer, they can't properly defend themselves. Even though this guy thinks he's some kind of genius, it's pretty clear he's mentally ill. That just slows everything down and can even violate his right to a fair trial, which could mean all his charges get dismissed. Plus, if he doesn't understand the charges or how the process works, it's like trying to play chess without knowing the rules. Total chaos. Alright, let's get back into it.
I'm going to wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels, excuse me,
Evaluation.
What labels me incompetent? My intelligence, because I have a high IQ?
No, that's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number. He did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
I'm almost positive this competency review is going to show that this guy is mentally ill. I mean, he's racked up so many felonies, and it just feels like this cycle is never going to stop. Don't get me wrong, I'm all for giving people second chances, but it seems like he's already burned through a whole stack of them. Honestly, I can't tell if he's genuinely mentally ill or just acting like a typical sovereign citizen, thinking he's above the law. The fact that he was caught messing with his stuff in public makes me lean toward him being a little unhinged. What do you guys think? Did the judges handle this hearing the right way? Personally, I think they did everything they could. Maybe if they had held him in contempt, it might have changed his attitude. But who knows? Drop your thoughts in the comments, and if you're into content like this, don't forget to like and subscribe. Thanks so much for watching, and take care.